Let's start this lecture with an experiment, or perhaps more like a demonstration. I want you to open up your web browser on your phone or tablet or computer and go to google.com. Now, Google your own name, or any name of your choice. Chances are something will come up on you, even if it's only an address, or a place you once might have worked, or volunteer activity, or your time in a recent road race, if you're a runner. The better known that you are, or the name that you've selected, the more information you'll find. More importantly, from the online researcher's perspective, the Google algorithm works. Let's leave aside for the moment the complaints that Google tends to tweak its search methodology to prefer its own sites over those of its competitors. Outside of that, you can pretty much count on Google to quickly and accurately get you to some information about a particular name or topic. So here's the experiment part. Now I want you to go instead to a different Google website. For our purposes, let's use the one in England. The web address is google.co.uk. And when you're there, I want you to Google the same name again. The result looks more or less the same, doesn't it? But I want you to scroll all the way to the bottom of the web page on the UK website. What do you see? There's a small puzzling line that reads, quote, "Some results may have been removed under data protection law in Europe." That text isn't found at the US website. What does it mean? And now, one final piece of the experiment. Do another Google search on the UK website, but this time, type in the name of a US president. Scroll down. There's the same little blurb. The Google website in the UK is different somehow. And if you speak German or French and go to the .de or .fr version of Google, you'll see the same notice there too. Of course, not in English. In discussions of surveillance, civil liberty, and privacy, many of us often limit ourselves to American concepts of law and liberty, and to the American experience of spying by US intelligence agencies and commercial surveillance by American companies. That's natural, I suppose. After all, I'm an American lawyer, and that's my experience. Most Great Courses customers are American as well. But the American approach to these issues is not universal. And we will see in this lecture on European views, America is something of an outlier on these issues compared with other Western nations. That said, the West, generally speaking, is aligned on the concepts of privacy, civil liberties, and autonomy, values that we all honor, albeit in different ways. Such ideas are hardly known, much less practiced, in many of the authoritarian countries around the globe. Put another way, it's unlikely you'll find a course like this one in Russia or Saudi Arabia. And if we were to be talking about privacy or civil liberties in China, the discussion would be very much different from what we describe in America and Europe. The concepts just don't translate well. So now, let's look at Europe and this curious provision that some results may have been removed. The caveat is relatively new. You would not have seen it before 2014. What it reflects is a uniquely European way of attempting to protect privacy and civil liberties. Let's start with the basics. For Europeans, privacy is a right. For Americans, it probably isn't. The right to privacy in Europe is considered so fundamental that it is enshrined in the European Charter of Fundamental Rights. Article 8 states that everyone has the right to the protection of personal data concerning him or her. The basic rules underlying privacy rights for members of the European Union are set forth in a pan-European rule known as the European Union Data Protection Directive. That directive controls how European companies can process personal data. The directive applies to electronic filing systems and old-fashioned paper ones. The data covered by the directive is information about an individual that somehow identifies a person by name or otherwise. It's what we would call personally identifiable information. One oddity is that these pan-European directives are not self-executing. Instead, they're treated as a baseline of guidance for each member state. And then each national government in Europe is responsible for implementing the directive. As you might imagine, there's a fair bit of variation between, say, Germany and Greece. But the directive serves as the core guiding principle. And since it was adopted in 1995, every country in the European Union has implemented it. The directive begins by laying down basic privacy principles. These might be familiar to you since they're derived from a set of internationally recognized practices for addressing information about individuals known as the Fair Information Practices. They essentially codify the requirement that information should be collected for specific, legitimate purposes only, and be stored in an individually identifiable form no longer than necessary. The European Directive also states that the person who the information is about has some rights of his or her own. In particular, a company collecting such information must give the person, who we call the data subject, notice explaining everything about the data collection. That is, the person who is the subject to this information sweep is entitled to know who is collecting the data and why it's being collected, as well as who will have access to it. There's also a transparency requirement, so that the data subject, that is, the person, can have access to the collected information and correct it if needed. There is, however, one gaping hole in the data directive. It doesn't apply to participating European governments. The member states exempted themselves from the directive to the extent that it might apply to many of the state's own operations. So, for example, the directive's requirements don't apply to matters of taxation or criminal matters or matters of national security. The European Parliament has considered revisions to the data directive that would, at least partially, close that loophole, but national governments have stood in opposition. With that background, let's turn to an explanation of how European privacy works. First, we'll look at the commercial sphere, and then we'll examine government surveillance. In the United States, the two principal and competing ways of protecting privacy have been to restrict collection and to restrict processing. In other words, we sometimes protect privacy and civil liberties by saying to a company, "This is data you may not collect in the first instance." The other limit is on processing, or what we sometimes call use. The idea that you can collect the data all you want, but use it only for the specific purpose that you collected it for. Or perhaps that you can use it for another purpose, but only with permission from a court, or a supervisor, or some other authority. The European model has one other, different way of protecting privacy. It allows people who feel that their privacy has been infringed upon to request and require that even truthful information about them be deleted or obscured. The Europeans call this the right to be forgotten. For many years, this concept was discussed and argued about on the other side of the Atlantic. It even had some resonance in popular culture in Europe. The United Kingdom, for example, generally holds that after some unspecified period of time, criminal convictions can become spent or exhausted on the expectation that the offenders have been rehabilitated, so that their prior criminal acts shouldn't be relevant, say, to an employment decision. France has adopted a similar view, what the French call le droit d'oubli, or the right to oblivion. But this right to be forgotten didn't really come to prominence until May 2014, when the European Court of Justice, Europe's highest judicial body, akin in some ways to the US Supreme Court, considered a case brought by a Spanish man named Mario Costeja Gonzalez. Back in 1998, Mr. Costeja Gonzalez had his foreclosed home sold at auction. He later paid that debt, but the fact that he'd been a debtor was recorded for posterity in a digitized 1998 article in the La Vanguardia newspaper. Mr. Costeja Gonzalez originally complained to the local Spanish Data Protection Agency, asking for the article to be removed from the web. But the agency rejected his complaint on the grounds that the newspaper article was lawful and accurate. The authority did, however, accept a complaint against Google and ask the US company to remove links to the article from the search results that were derived from Mr. Costeja Gonzalez's name, even though Google wasn't the author of the article. The argument was that the search engine was at fault because it made the article visible to a large audience. Rather than just delete links to the offending article, Google sued the data authority in Spanish court. And that national court, in turn, referred some of the questions before it to the European Court of Justice. The European Court of Justice ruled that search engines are responsible for the content they point to, and thus Google was required to comply with EU data privacy laws. And that, in turn, means that individuals can ask internet search sites to remove links to web pages that contain inadequate, irrelevant, or no longer relevant information in the results page for searches of their names. Since that ruling, Google has had requests to remove more than 300,000 links and has removed 40% of those requested. And that number grows every day. And so we have the warning at the bottom of the Google page. That's Google's way of letting you know that the subject of your search might have asked for his or her name to have been removed from an old link. There are any number of oddities that flow from this idea. Things that are, at least at first glance, strange to American sensibilities. Let's unpack a few of them to see what it all means. First, and at the top of our list, let's accept at face value that this is a direction to delete truthful information. In the United States, we'd have a strong preference for allowing the publication of accurate information. We allow lawsuits for libel, of course, when the statements are said to be untrue, but everyone has heard the adage that truth is an absolute defense to libel and defamation suits. That understanding is reflected in American law. Consider, for example, the case of Sidis versus FR Publishing Co. William James Sidis was a child prodigy with extraordinary math skills. As he grew up, he faded into happy obscurity, an anonymity that was torn away when the New Yorker magazine wrote an article about him. Sidis sued, and he lost. Essentially, the court said that for someone who is once a subject of public interest, however modest, there was no right to control the dissemination of truthful facts about him. The court thought that there was a social value in facts about a public person being known, and that you couldn't just opt out of celebrity status. Fast forward from the Sidis case to a more recent issue. You might remember that Sony, the movie-making company, was hacked, probably by someone from North Korea. The hackers released a lot of internal corporate financial data that was embarrassing to company officials. But they also released a trove of internal emails, many of which were pretty mundane. WikiLeaks then decided to host all of those emails in a searchable database, and gossip columnists mined them for tidbits of information. Thanks to Jezebel, which is an online gossip magazine, we know, for example, exactly which feminine products Amy Pascal uses. Who's Amy Pascal? She's the former CEO of Sony who lost her job after the hack. The poor cybersecurity job she did is surely a matter of public interest, and was the reason she lost her job. But here in the United States, we now also know that she uses hair coloring in places other than her head. The public disclosures of private information was deeply embarrassing, I'm sure. Just think what the public disclosure of your medical, or financial, or shopping list would be like, and you can imagine how Ms. Pascal must have felt. But here in the United States, she had no recourse. She was considered a public figure, and the courts would more than likely protect Jezebel magazine from any lawsuit for damages. Europe is different, however. There, Amy Pascal might easily have sought to have what she saw as irrelevant information delinked from the search engines. Why does the United States hold such a contrary position, respective of European sensibilities? It's tied to quintessentially American ideas about freedom of speech and freedom of expression. Americans want a free, uncensored press, not a world where public figures can edit their own histories. To wrap up this short discussion, consider the case of George Osborne, a member of Britain's Conservative Party. Apparently, he asked Google to remove links to articles reporting that his brother had converted to Islam. Is that protecting his brother's privacy and his own? Or is it censoring the truth and whitewashing public knowledge of a public figure? So here are a few more questions. All also quite difficult, though probably less significant in terms of deep social distinctions across the Atlantic than the question of principle we've just been talking about. So first, why Google? I mean, in other words, why is it that Google has to edit the search results, but that the newspaper it is sourcing doesn't have to change its digitized records? In fact, the European Court of Justice explicitly said that it couldn't make the newspaper edit its records. So this isn't about wiping out the truth, really. It's just about making it harder to find. You sort of have to wonder a little bit about a right that is protected by going after the middleman rather than the original source of the bad information. Second, who judges? Who gets to say what is and is not relevant? Today, the answer is that Google does, and the other search engines like Bing and Yahoo. They take in the requests and process them based on their own assessment of relevance and importance. And that's pretty strange, too. We have a private sector company in the United States making decisions about what will and will not be shown to people in Europe. Not the Europeans, and not a European government or court. If I were a European, I might not like that very much either. Third question. Is this right global? You can find the same data that is missing in Europe on an American website. There's even a website called Hidden from Google, where you can find the missing data. European policymakers don't like this. They can't do much about Hidden from Google, but they do say that Google and other search engines are required to remove links from all result pages in all countries, regardless of where the search takes place. That's pretty hard to accept, I think. It means that Europeans would decide what information citizens of every other nation can access. Google has so far refused to comply with these demands, but only time will tell whether it can continue to resist. Finally, and to demonstrate the complexity of these issues, consider the irony that Spain's Mr. Costeja Gonzalez sued so that his prior default and home foreclosure would not be widely known. Yet now, precisely because of his success, the formulation of Europe's right to forget policy will be forever linked with those personal embarrassments and his name. At one level, you have to feel almost a bit sorry for the gentleman. Or maybe you think he should have been careful what he wished for. But the broader point is that it is difficult to fight for your own privacy because in doing so, you inevitably lose some of it. The right to be forgotten is but one aspect of how differently the Europeans view privacy compared to most Americans. And it pertains mostly to commercial data aggregators, such as Google or Bing. So let's change the focus a bit now and ask a different question. How do European views differ with regard to privacy and government surveillance? One perception is that Europeans are much less tolerant of government surveillance than Americans are. The massive, unauthorized data disclosures by the former National Security Agency subcontractor Edward Snowden, revealing some of the hidden practices of American spycraft and diplomatic relations, seem to have only reinforced the uneasiness of Europeans and others with the idea of American surveillance. We can recall, for example, how angry the German public seemed to be when National Security Agency eavesdropping appeared to extend to include listening in on German Chancellor Angela Merkel's cell phone. After a Spanish newspaper reported that the NSA had monitored more than 60 million phone calls in Spain during a single month, the Spanish foreign minister called that magnitude of incursion unacceptable. A common reaction across Europe was to publicly call for suspending intelligence sharing agreements across the Atlantic. In truth, however, many observers think that the European reaction was quite muted in practice. One would be hard-pressed to find any transatlantic cooperation that was actually suspended. Instead, as the George Washington University political scientist Henry Farrell has written, the real change was more in the nature of atmospherics rather than in the nature of practical change. Farrell specializes in Europe, and his colleague Martha Finamore is an expert on international institutions. They wrote in Foreign Affairs magazine that the revelations that the U.S. had spied so extensively on its allies reduced the Americans' space for hypocrisy. Quote, "Hypocrisy is central to Washington's soft power," Farrell and Finamore wrote. "Its ability to get other countries to accept the legitimacy of its actions, yet few Americans appreciate its role. The reason the United States has until now suffered few consequences from such hypocrisy," they continued, "is that other states have a strong interest in turning a blind eye. Given how much they benefit from the global public goods that Washington provides, they have little interest in calling the hegemon on its bad behavior. Public criticism risks pushing the U.S. government towards self-interested positions that would undermine the larger world order." In short, Farrell and Finamore contend hypocrisy sometimes is useful in achieving a good result. We want the world order to aspire to high-minded values, and we want the United States to interact with international institutions such as the United Nations and the World Trade Organization on the basis of those higher ideals. U.S. sponsorship of those ideals and institutions contributes to their legitimacy. But in its national capacity, the United States doesn't always practice what it preaches. Another indication that there's less space between the United States and its allies than perhaps meets the eye is the reaction that various nations had to the Snowden disclosures. After the Charlie Hebdo massacres in France, during which two militant brothers forced their way into the offices of a satirical newspaper and killed 12 people, the French Assembly overwhelmingly approved legislation that gave authorities their most intrusive domestic spying abilities ever, with almost no judicial oversight. The law gave French officials the right to tap cell phones, read emails, and force internet providers to comply with government requests to sift through virtually all of their subscribers' communications. Among the types of surveillance that the French intelligence services were authorized to carry out was the bulk collection and analysis of metadata, similar to that which has been performed by the NSA. The French intelligence services could also request a right to put teeny microphones in a room, or on objects such as a car or in computers, or place antennas to capture telephone conversations, or the mechanisms that capture text messages. French citizens and foreigners alike could be tapped. At almost the same time that the French were moving to expand government surveillance powers, a controversy erupted in Germany. It appeared that the German intelligence agency, known as BND, had been helping the United States National Security Agency by conducting electronic surveillance and data analysis of other European countries, most particularly the French. Needless to say, the French were none too pleased to learn this. And because the German cooperation with the United States appeared to contradict earlier German protestations against NSA surveillance, charges of hypocrisy flew. All of that should sound familiar to Americans, as it sounds a lot like the controversies and challenges we often face here. And so the real question is not whether privacy is better protected in Europe. Europe does have more comprehensive consumer privacy rules than the United States, but those seem inapplicable to the government surveillance question. Nor is the real question whether or not government surveillance is less in Europe. As to that issue, I think that Europe and the United States are converging rather than diverging. At least the French example suggests that's the case. And so the question we might want to ask is, how does American intelligence oversight stack up next to European intelligence oversight? And if that's the question, I'd say the U.S. law and oversight of its intelligence agencies is more robust, not less, compared with Europe. This might be a surprising conclusion, but it is nonetheless, I think, an accurate one. Judicial limitations are more stringent in the United States, and transparency is greater, too. Let's talk about the law. A comprehensive analysis of worldwide surveillance laws undertaken by the Center for Democracy and Technology in Washington, which describes itself as a champion of global online civil liberties and human rights, shows just how little is required in most countries around the world, including Europe, for undertaking national security surveillance. For example, under the United Kingdom's Regulation of Investigatory Powers Act, that type of surveillance can be approved by the Home Secretary. Germany authorizes such surveillance through a parliamentary committee. Other examples abound. Australia, France, India, Netherlands, New Zealand, Turkey, all allow national security surveillance based on ministerial, that is, political, rather than judicial approval. Yet, European courts have found these types of rules satisfy the European Convention on Human Rights. On transparency, the United States continues to declassify more and more details of its intelligence operations in the wake of the Snowden revelations. European agencies do much less in terms of public disclosure. That's not my conclusion. It's, for example, the conclusion of a United Kingdom court that oversees UK intelligence services, known as the Investigatory Powers Tribunal. That court recently concluded that the British intelligence services needed to be much more transparent about the rules under which they operate. And in most countries around the globe, even disclosure of the existence of a surveillance request is considered unlawful. And what about the actual volume of surveillance that occurs? After all, what really matters is not necessarily the legal architecture, but how frequently surveillance occurs. As you might imagine, data on this is hard to come by. Some countries don't permit any disclosure at all. Most authorize disclosure only of bulk numbers. So let's take a look at one company, Google. In the interest of transparency, Google issues a public report every 6 months detailing how many requests for users' data they've received from governments around the globe. During one recent 6-month period, France made 3,002 requests. Germany made 3,338 requests. The United Kingdom made 1,535 requests. And the United States made 12,539 requests. On a per capita basis, using each country's population as the denominator and the number of user data requests as the numerator, France requested information on 1 out of every 22,000 residents. Germany, 1 out of every 24,000. The United States, 1 out of every 25,000, and the UK, 1 out of every 42,000. On this basis, we might say that France is a leader in government surveillance, though not by much. And so, it is fair to ask, is America as bad as some might think? In that regard, the best answer I can give is, maybe not. It seems very clear that commercial privacy is better protected in Europe. But in the context of government surveillance, it might be that America does at least as good a job. The good news, of course, is that at least we have a choice. In Europe and the United States, citizens and their representatives are involved in important decisions about privacy, civil liberties, and surveillance. This involvement is far from perfect. But as we muse on the differences between the United States and its European allies, it is worth reminding ourselves that our differences pale in comparison to how privacy is treated in more authoritarian nations.